Raise your hands if you can hear me. This isn't a good start.
Raise your hands if you can hear Bruce.
There it is. What's going on, bro?
Young man sits under
Oh
a
man,
tree
I'm
and
just
I'm
I'm pumped for this trial to start.
I am too. It's funny because I was like setting up my stream, like, all right, I'm gonna go live and watch this, and I'm like, then I get a notification, like, oh my god, Nick is going live. So I'm watching you, and I forgot about mine totally because I'm so entertained with yours. I'm like, oh my god. So when you asked me to come on, I'm like, all right, fuck it, it's great. I'll just come on with you and watch this crap.
Yeah, this is gonna be a disaster.
Give myself half
we're gonna see if they get through. What?
I can't wait till he is acquitted, right? Because it's an obvious acquittal. I don't know how anybody can have read the complaint, right? There's no way you can read that complaint.
Yes,
where the complaint says, where the complaint literally says the guy lunges for Kyle's gun and he shoots him at the end, right? All the witnesses say that. And I'm like, how can you charge someone when the guy is lunging for the kid's gun, right? It's like, it's in the complaint. So
right,
I don't know. This is a political prosecution, and usually you guys know me. I don't say stuff like that. Like I'm literally the last one to say stuff like that. This is crazy.
Right. You're like the most. You're like, no. Let's take a reasonable look at this. Is there any other option other than this is some sort of, conspiracy or go-to? There's these reasonable explanations that would make sense. You're very, very fair on that. And I've been trying to be very fair on this one. I've been trying. It's hard because you're like, I mean, at the end of the day, and let me know what you think about this. At the end of the day, you got 3 bodies. Or 2 bodies and one evaporated bicep. And that is one of the biggest issues where it's like, I don't think that Kyle should be prosecuted. I think he should be acquitted. I think you almost wanted to see a pretrial dismissal based on the complaint. But at the end of the day, like, that's the justification for the prosecutor is that, well, we got these bodies here. Like, what do you want me to do with them? I got to prosecute somebody, which he doesn't actually have to. But that's I think that's the justification against like a malicious prosecution charge or something like that, or suit.
It's you know what? I understand because probable cause is such a low bar, right? It's like, do you have enough? Do you believe this guy committed a crime? Okay, that I think you're there. But I think that because I hadn't read the complaint until after I did my video, and then reading that complaint. Because in my video, I'll come to the conclusion it was obvious self-defense. How more obvious could it be? But then after I read the complaint,
is this your recent video on it or your early video on it?
No, my early video on it. My early video on it when it first happened, I said it was I said the point. This is 100% self-defense. Then they had the complaint. When I read that, I said, how can you survive a motion to dismiss when the complaint it's read like it was self-defense? The damn complaint was read like self-defense. So I don't know.
This sprinter set records in both
Same
the 100
thing happened
and 200
to me.
meters
Oh my
in the
gosh.
1988 Olympics.
Bruce, buddy, you're talking over me here. This happened to me too when I was first covering this case. I figured when they charged him and I read the complaint, it would be just a hack job of a complaint. Says that Kyle Rittenhouse murdered these people in cold blood while they were drinking coffee between shifts, helping at the local children's shelter or something, right? And then I'm like, look, they're gonna write up this nasty complaint that leaves out all the facts. And then I read it, and I'm like, did the defense attorney write this complaint? Like, this is exactly what you would want written down. So it's insane. And I do think he's going to get an acquittal. It'll be interesting. What do you think about this? So Barnes has been talking for the past month and a half about jury selection being a big part of it. Says that Free Kyle USA has brought in all this money, and they had basically a team of experts put together. Behavioral specialists and all that to do jury selection. And just 2 days ago now, I think it is, Richards has apparently cut Barnes off from Kyle Rittenhouse, He and his team are not part
For
of jury
400, this
selection,
state has
and Richards is going it
beer and
alone
music,
to
the
do it. How do you
Anheuser-Busch
what do you make of all that?
And the Scott Joplin residence.
Well, number one, I'm going to say
Missouri,
this: Barnes, I think, is
Denver,
one of the
I know
best
you're not
attorneys
from
on the
there,
planet,
you
right?
said Missouri.
I want to make it extremely clear. If Barnes says something is Y, and Nate the lawyer says something is X, preemptively, I'm telling you, you should believe what Barnes says. And then,
Listen
if
to
I'm able
Barnes.
to, because I would listen to Barnes, right? Barnes has more legal experience than I have, so I'm not ashamed to say that because he just does. If I need a lawyer, I'm going to Nick or Barnes. I'm like, hey, Nick or Barnes, I need help, right? That's because
I'm referring you to Barnes
know.
anyway.
Yeah, so that's not secret. But on one end though, just because you do have all experience, I don't know how great he is in these type of criminal prosecutions. When it comes to tax law, Barnes is your guy. When it comes to defamation, Barnes is your guy. But when you're talking about assaults and murders, it might be a little different. But from what Barnes is saying, I think they are making the defense is making a huge mistake in two instances. One, you have the jury consultants come in, and if they tell you something you don't like, you don't have to follow their thing. And this is all for free. The more information, the better it is to help your clients. So I don't understand why they would want to cut Barnes off unless they are trying to cut Barnes off from credit because they know Barnes is a prominent lawyer. He's and a lot of people are going to say this is Barnes, and Barnes is, and let's just be honest. Barnes knows that if I'm getting jury consultants because I want to make sure I got a good win versus taking a chance. And I think this other attorney doesn't want Barnes to get that type of love and that type of notoriety, and that's why they probably cut him off. It's a horrible mistake, but if the case wasn't such a slam dunk case, though, I would be more concerned. But I don't see how this survives appeal. Even if he's convicted, I would write the appeal for free. That no reasonable jury could come to those conclusions based on these facts, right? I would write that appeal. So go ahead.
I was going to say there has to be some sort of landmark fact that's going to come out at trial, what's his name? Binger is going to have to bring something to trial that nobody else has seen. And the only thing so far that I've heard hinted about is this FLIR footage from the FBI from the drone. And this, because you heard about that, right? Like that they allegedly have some footage that Kyle was chasing Joseph Rosenbaum prior to Joseph Rosenbaum chasing Kyle.
And can you hear me over in the?
And even there, I think that's a stretch because Kyle was retreating pretty clearly and obviously. And under Wisconsin law, he doesn't have a duty to retreat unless he instigated. But even if he did retreat.
We're here to select a jury today, and it's a criminal case.
But I'm so angry. You know what? The thing that makes me angry about this case, it's like I was arguing with a friend of mine who's a liberal. They were like, oh, he went, he got a gun. He went out there to shoot black people. I'm like, so this is one of the first cases I've ever seen where the racist didn't shoot any black people. He shot a whole bunch of white people. And we're saying that it's a racist case. I'm like, what racism are we saying? He shot a whole bunch of white people. If he shot black people, then I would say, okay, maybe we can look at race, but there's no racism here. He didn't shoot any black people. The racist that was there to kill black people didn't kill any black people.
All right. So
how did you feel about the prosecutor making the suggestion that because Rosenbaum was unarmed,
excellent.
And Kyle was armed, that he wasn't sure if you could defend yourself with lethal force against someone who is unarmed. Did you catch that?
That was the issue with the prosecution is that I think the prosecutor knows he has lost. I think the prosecutor, and that's why you make those arguments. You make arguments like that when you know you don't have a good case, right? Well, someone with a gun, and because in general terms, someone with a gun does have power. But it's not only about what you have, but what the person is doing to get you. You know what I'm saying? What the person is doing. And someone chasing the person with the gun and lunging to grab that gun, how do you not shoot them? Especially when someone is shooting behind you, because a lot of people don't realize when Kyle was running from Rosenbaum, people were shooting up in the air behind him. So just imagine you running with your gun, somebody's chasing you, and people are shooting, and you're hearing gunshots behind you. You turn around and someone lunges at you, grabbing at your gun, trying to grab your gun. What do? Do you hold your gun and just wait to see what happens? I don't think so. I think you let those shots go, and and let a jury determine whether you're self-defense or not.
Right. I remembered what I wanted to say. The other reason that the rioters, looters, arsonists labels matter is because it goes to the state of mind of the defendant, which is a critical aspect of all of this. If you see a guy burning dumpsters and pushing them at gas stations or whatever, if you see that, your state of mind about that person is going to be different than someone who is watering flowers on the side of the road. So when the guy watering flowers is chasing you, you might think he's returning your wallet, whereas the other guy's chasing you, you might think he's trying to commit some other criminal act against you. Yeah. And so that was an insane place where you're arguing clearly about state of mind evidence and the right to even introduce it. And basically all of the motions in limine that the prosecution brought, to me, it was like all of your motions here are better handled through objections if the issue arises at trial. None of these things need to be discarded out of hand.
Who is Tom Thumb?
Yeah. And for a lot of people who maybe for the benefit of the audience, Kyle Rittenhouse doesn't have to prove that he acted in self-defense. The prosecutor has to prove that Kyle didn't act in self-defense, that he acted illegally. And a lot of people keep thinking that Kyle's got to go out there and prove it. It's the prosecution that's got to prove beyond a reasonable doubt that Kyle was, number one, unreasonable in his belief processes, and the use of force that he did use was too much. It was like somebody puts up their hands for boxing and you pull out a gun. That's too much force even for self-defense. So those are the two hurdles that I think the prosecution has to get over, and I just don't think you have it here when it comes to this, because especially with the testimony, it's sad to say this because I don't usually say this, but I'm hoping the right outcome comes here, because it's a shame that people are only seeing this case white and black instead of just what the law is behind it. Because I'm assuming that any regular person out there who was in Kyle Rittenhouse's position would have done the same thing. They would have done the same thing, and that's the sad part about it. They're trying to give up their rights to self-defense because they feel that this 17-year-old kid was intended to go out there and kill people.
Struggle a little bit with it, but it is.
But I can tell you right now, the prosecutors, they want Black Lives Matter protesters. They want people who are sympathetic to all that. That's who they want in the jury. If the cops people want white, either middle income to high middle income residents to be on that jury, who predominantly are white or even black, but they're looking predominantly for white,
who are either in the audience here or over in the county
and the prosecution looking for black low income jurors.
Need to listen carefully.
It's a shame, but that's the game that's going to be played.
Since you will need
that's kind of strange.
You can remove each side can remove 7 of you without needing to give any reason at all. And that'll leave us with the 20 jurors we want to try the case. So that's the reason for 34. That's the reason why we replace, so that we'll always have 34 here from which those 14 strikes can be taken.
Okay.
You're probably wondering, what's he talking about?
Just so everybody understands, 34 in the box. Each side gets 7 strikes, and if the 14 strikes go in, the 20 that's left is your jury.
Full-fledged juror. The selection process takes place at the end. When we go to verdict, when we go to deliberation, at the end of the trial, if there are more than 12 jurors, then we will strike off whatever number is necessary to get down to that number. So maybe it'll be 8, maybe it'll be 2. We don't know yet. It depends on if there's any family emergencies or illnesses that mean that we have to discharge a juror. And so we'll keep 20 as long as we can. And then, as I say, when we go to deliberation, there'll be 20 who will decide the case. I took a larger number than usual.
Obviously.
Okay.
Because this trial is going to last a couple of weeks. That's what the lawyers tell me. I suspect they're probably estimating a little bit on the high side, which is what I want them to do.
This trial really should last about a day.
I don't want to give you a false impression.
Yeah, this usually used to be a 2-week trial at most, because you got video. Just play the video, and you got 3 or 4
2 weeks
people to give questions.
Just in case.
There's a lot of video on this. They're actually, I mean, from different angles of different moments of the night. And it's kind of messy when you see someone try and put them all together.
The anticipated length of the trial is 2 weeks. We're going to ask. I'm going to ask about 2 weeks plus 2 days.
If they even go 2 weeks though, because
we start.
I can easily see a motion dismissed after the prosecution.
We work until around noon. We take a break at noon, and food is being brought in for your lunches, and we'll continue at
jury
about
lunch.
An hour's
That's good.
delay.
Right.
But you should count on being in this building in the jury room for the duration of the trial. So that's
don't tell me
number
what
one.
to do.
And number
Judge.
2 is the duration of the trial.
I'll come and go as I please.
There is I'm going to place this at
I'd be the worst juror. I'd be late all the time.
Less than a 1% chance. For some reason, I would order during the trial that you would be sequestered, which would mean that you would.
I don't see why though.
Housed
Why
in
you
a
need to have
hotel
these jurors sequestered?
In individual.
Yeah, he said
rooms.
less than 1% chance.
And you'd be provided with all of your meals all day long. You'd have limited access to television and internet and that type of thing. But
what do you think about a juror screaming, remember jury nullification as they get struck
since I was
from the courtroom?
statutorily required to do so.
Yeah.
When I started the system 50 years ago.
That might be a mistrial.
The jury was required to be sequestered. So
they're going to sequester?
I'm familiar with the process, and I know how onerous it is.
No, he's saying back in the day they used to be required, but it's not anymore.
Every way I can, but I can't rule it out entirely. As I say, I'm being very honest with you when I tell you there is less than a 1% chance, in my estimation, that we would come to that. But I don't want to spring it on you suddenly. That's pretty painful.
I like this judge. He's relaxed.
In the back row,
like,
just the back row. That's
before. Like this is just
1 through 11 in the back.
Did you see the?
Is there anyone
after the victim's hearing? The hit pieces on him started coming out.
Yeah. I always give a little.
Again, this was a race. This is a racist judge.
About
insane.
Well, they're often about me.
Yeah, he's a racist judge. And look at all these bad decisions. It's like, yeah, he's been on the bench 50 years. He's going to have some bad ones.
It was there was a lot of unpopularity. I'm going to introduce the case to you. It's entitled "The State Against Kyle Rittenhouse," and when a person or entity feels that some wrong has been done that can be addressed by the law, a complaint can be filed with the clerk of the court asking for some legal action to be taken. And that document is known as exactly that, the complaint. And that's where the word plaintiff comes from. The person or entity which files the complaint is the plaintiff. And in a criminal case, the state is always the plaintiff and is typically represented by the district attorney of the county, and in this case is represented. The case is presented by Assistant District Attorney Thomas Binger and Assistant District Attorney James Krause.
Binger ran for district attorney of a different county and lost.
Is brought is known as the defendant because of the role of defending the action, and the defendant in this case is a gentleman by the name of Kyle Rittenhouse. And he is here with his lawyers, Mr. Mark Richards and Mr. Corey Sharafasi. and Ms. Natalie Wisco. And after some preliminary activity has taken place on the case, the district attorney makes a formal charge selection and presents it to the court in a document which is known as the information. It gets its name from its informative function, and it can contain one or more allegations or charges of criminal activity. You hear that referred to in your experience in life or on television or whatever as counts. And in this case, the information contains 7 counts alleging various levels of unlawful activity. The first charge is charges that on the 25th of August of 2020 at the city of Kenosha in this county, that the defendant recklessly caused the death of Joseph D. Rosenbaum under circumstances which show utter disregard for human life. This is a crime which is literally known as reckless endangerment of the, reckless homicide.
Reckless homicide on him is a weird charge.
The second count charges defendant with an identical, another charge is first degree recklessly endangering safety, and alleges that at the same time and place, the defendant recklessly endangered the safety of another, Richard McGinniss, under circumstances which show utter disregard for human life. The third count charges the defendant committed an additional crime of reckless endangerment of the first degree at the same time and place by recklessly endangering the safety of an
great witness too
under circumstances showing an utter disregard for human life.
He's a great witness for Kyle.
The fourth count
That's the funniest
charges that
part.
at the same time and place, the defendant caused the death of Anthony M. Huber with intent to kill that person. This is a charge literally known as intentional homicide of the first degree. The fifth count charges that at the same time and place, the defendant attempted to cause the death of Gage Grosskreutz with intent to kill that person. This is a crime literally known as attempted intentional homicide of the first degree. The sixth count charges.
Yeah, they charged him with first degree on Huber.
Place, the defendant being a person under the age of 18,
premeditation went into him shooting Huber?
Weapon. This is a crime literally known as possession of a dangerous weapon by a person under 18. And the seventh count charges that at the same time and place, the defendant committed the crime.
I think it should be dismissed still, but doesn't look like judge is going to do it.
Comply with the order of local with an order of local government emergency management activity.
You got him on the misdemeanor curfew charge.
Intentionally failed to comply with
I think you get him on both.
By an agent of the state or of a local unit of government.
If we're being fair, I think the last two you got him close, the gun and the curfew. But those are the bullshit. If I was the jury, I would even acquit him on those bullshit charges, right? Because everybody else here was involved in the curfew.
And
why are we just picking this one guy?
Right.
And everybody else has.
I should add also that with respect to the first 5 counts,
I still think that the law does not cover Kyle's activity for a gun.
Armed with a dangerous weapon, using a dangerous weapon. To each of these charges in the information, the defendant has entered a plea of not guilty, which is a demand that every material allegation of each of these counts be proved with respect to the first 6 counts beyond a reasonable doubt, and as to the 7th count, by evidence which is clear, convincing, and satisfactory to a reasonable certainty. And
he still hasn't finally ruled on that motion to dismiss.
The defendant is not obliged to prove his innocence.
I don't think so.
The entire burden of proof is upon the district attorney to establish the guilt of the defendant beyond a reasonable doubt. If the state is unable to sustain that burden, then the jury is bound to find the defendant not guilty. I'm going to ask I think first I'm going to give you some background on the case. And this case has enjoyed a lot of publicity. And we're going to talk about that in a little bit as well. But I'm going to give you some of what the complaint alleges, because the information is a formal statement of the charge, but there's more of the district attorney's factual assertions contained in the complaint. And it is alleged that on the night in question, there was a good deal of public unrest in the central area of the city of Kenosha. And
we've never heard of this. I don't remember
it
this
is
happening.
alleged that the defendant, Kyle Rittenhouse, was in Kenosha at that time, that he was armed with a rifle, and that also in the city at that particular time were Joseph Rosenbaum, Richard McGinniss, this unknown person who was referred to in the third count, Anthony Huber, and Gage Grosskreutz, and that during the course of the evening, there was a period when there was close contact between Mr. Rosenbaum and the defendant, and the district attorney alleges that it ended with the defendant firing a bullet, or firing a series of bullets, and one of which brought about the death of Mr. Rosenbaum.
I love how torturous this description has to be.
Mr. McGinniss, he was in the close proximity
Just the
of
allegation.
that incident in which that gunfire
So
occurred.
So what they're saying is because he
And
shot at Rosenbaum, even in self-defense, because McGinniss was behind Rosenbaum, and he could have hit McGinniss, then that's why he's being charged
after
with
that
reckless engagement of
incident,
McGinniss.
it is alleged
because
by the
McGinniss
district
could have been
attorney
hit.
that
It makes sense, but the self-defense
Mr.
will negate it.
Wouldn't
Because
negate
if you're
that
acting-
McGinniss case, yeah.
started
If you're acting in
northbound on
acting in
Sheridan
justifiable
Road, and the incident,
self-defense,
by
then
the
you're
way,
not acting recklessly
involving
by
Mr.
definition.
Correct.
Rosenbaum is
Correct. Which I believe
charged
I
with
believe the
murder,
first charge is
63rd,
done.
and Sheridan in
He's
a
definitely acting
place
in
called the
self-defense.
Car Source.
I think if he wins on
And then after that,
I think if he
it is
wins
alleged
on
that Mr.
Rosenbaum,
Rittenhouse
he wins the
was
case
walking
entirely.
down the
To me,
center
I
of
mean that's the
Sheridan Road, northbound,
Ugh.
and
Because he can win on Rosenbaum, but lose on
one
the other
point,
people. Because he
there
he
were
won
Could,
after
but I-
engagement, right?
in the street,
but I don't
who
think he
appeared to
will
be
on
in
this
pursuit.
set of
The
facts.
district
I
attorney
think
claims
he's
in his
he's
complaint
trying to
that,
go to
Mr.
police after being attacked,
Rittenhouse,
firing a weapon.
stumbled and fell, and then there were a
He's running
series of
towards
people who
police.
came
I think
into close proximity
just
with him,
the psychological aspect
and
of it.
that
It's all
at that
continuous, yeah.
point,
I get you.
began firing
Yeah.
at
I can see that.
three of them. The unknown person, Mr. Grosskreutz, next Mr.
We've passed 1,000 likes,
Huber,
so I'm
and
going to
then
drink
Mr.
some of this
Oh,
whiskey at
Grosskreutz,
10 in the
and
morning.
10 in the morning.
shots involving the unknown person. Mr. Huber was fatally struck, and Mr. Grosskreutz was sustained a gunshot wound. And that's what the case is about. Influence of another. This case has become very political. It was involved in the
Yes.
politics of the last election year.
Yes.
Oh, and Kyle has
To
2
this
months
day,
time
you could
served
go out-
in
you could go
Illinois.
out now and
Michael
read
O'Neill
things
So he'd be
pointed
done. Yeah, yeah. Well, actually, all Dick would be time served, right? The trial, actually. He'd be on
about
trial
this
would be time
case,
served.
most of which is written by people.
yeah.
Well,
Yeah,
he's
yeah.
not. He's been out.
I don't mean that there are no nothings. I mean
But still,
that they don't
under
know what you're going to know.
I know in
Those of you
some
who are
states,
selected for the jury,
if
who are
you're
going
if
to
you're
hear for
like the time
yourselves
which if
the
you're
real
going to trial for
evidence
2
in
months,
this
all
case.
that time
But there
counts as time
are-
served
there's something
because you're
called
still
the
within the
First
judicial
Amendment.
process.
That's another part of
for
our
going to all
Not
the
here.
court dates and stuff.
where they guarantee
oh,
the
all
right
right,
of
all
a
right.
free press.
Yeah, in
And it's
Minnesota,
the
time
price we
served
pay
is
for having a free
incarcerated.
press
So you have to
is
actually be
a
locked up. All
lot
right.
of irresponsible and sloppy journalism. This is not an attack
right.
on the media. We have I've read things about this case that were perfectly stated what had happened in this court.
That's
And
my
there
video,
are things
guys.
that I would
Oh, here he
think,
goes.
was I in the courtroom when that happened?
Oh, this
Um,
is good.
it can be frightening. So I'm not bashing anybody, but I'm going to talk about what you need to do, what you need to be thinking about if you're picked to hear this case, and how much reliance you can put on things that may be just sloppy, which is a vast amount of it. Some of it that is deliberately biased, that's out there, and sometimes from respectable media
Oh,
outlets.
he's salty.
Yeah.
He's salty. I
But
love that.
that's the price we pay for having a free press, because we value that. But we also value having a fair trial. So the critical thing you must remember is whatever you've read or heard about the case before, whatever you've been thinking about the case, you have to be in line with what these people who risked their lives for our freedom asked of us, demanded of us. Fair and impartial, based upon the evidence.
I was going to say fair and
Those who are picked
impartial
for this jury
based opinion.
will be in the front row seat to see exactly what
I
happened
like this judge.
and make a rational decision based on that. And anybody who's not on board
Honestly,
with
again,
deciding
the main
strictly
thing you
on
can
the
ask
evidence
for in a judge is
needs to tell
consistent
us
application of the
that. If you can't
rules,
do that,
an explanation of
then you can't be
reasoning.
fair,
Even
and
if
you're
they're
not
wrong,
in
at
step
least you
with what
can
the
get a
founders
sense of where they're going to be
expected
wrong.
and demanded.
Consistency is key.
So that's speech number 2.
Legal
Maybe that's
mindset
speech
says
number
sloppy journalism,
But,
not simping for the mainstream media.
so
Someone's going to be
I'll
on the
be
judicial hit
asking-
list.
What's going to happen is there'll be general voir dire. I'm going to ask.
Yeah, this is a huge misnomer that is propagating all over Twitter. They say if you're committing a criminal act, you are not entitled to self-defense. That is abjectly incorrect. Whether or not you're engaged in an ongoing criminal act has only a factual basis to do with your self-defense claim. And that factual basis is limited to the facts of, are you in reasonable fear of imminent death or bodily injury? Are you subjectively in fear of imminent death or bodily injury? And then finally, did you instigate or provoke the activity? So yeah, if you're engaged in the act of robbing a bank and a security guard pulls his gun on you and you shoot the security guard, you don't have a self-defense claim, even if you're in reasonable fear. But
Yes, correct.
most criminal activity, even being like you're a felon and you pick up a gun that's on the ground to defend yourself, you're in illegal possession of a firearm at that point. However, you're not prohibited from using it to self-defense. And
or even to save someone else.
Right. And so these weird commentators, because a lot of people think that since Kyle, quote unquote, was illegally carrying, for example, that he's precluded from a self-defense claim, or since he was out past curfew, that he's precluded from a self-defense claim. No,
was January
absolutely
12th
not.
of 1971. Thank you. Go ahead, Mr.
Wendy Rittenhouse, Faith Rittenhouse, Michael Rittenhouse, Ray DickHard, Charles Rosenbaum, Tamara Rosenbaum, Carrie Ann Swart,
We're
Thomas
so
Hazelton,
juvenile. We are
Joshua
so
Binninger,
juvenile.
and
Oh
Agent
my God.
Gibbs
His
from
name
Alcohol,
is
Tobacco, and
Ray
Firearms.
DickHard.
Yes. Yes.
he had
Go ahead.
Oh my
Dickard
God.
first. He
Horowitz.
corrected it.
Karen Bloom, John Huber Jr.,
Ah.
Nick Dennis, Chief
Layman.
David Devin Bennett,
I
Alicia
interviewed a guy
McCrae,
named Andrew Branca
Brandon Utarte
from
Childers,
lawofselfdefense.com
Angela Aker,
about the Ahmaud Arbery case.
Sarah
And
Castelli,
his
and Alan
one of his
Castelli.
contentions that was
Can
interesting
anybody,
about that
on those
case
names?
is both that Ahmaud
Um,
Arbery may have been justified
again?
in attacking
Okay, what's
what's
up?
his name, Michael.
The guys.
Yeah,
McMillan.
that he may have been
McMichaels.
Okay, so this
McMichaels.
is
yeah,
something that
McMichaels.
was actually
Greg
there was a
McMichaels or
live stream
whatever.
running that.
So he may have been justified in going
Okay.
after him, and
Can
that guy
you, even though
simultaneously
that
would still
is
be justified in shooting
claimed
him
to be a live
because
stream, I'm not suggesting it
one of the
isn't.
allegations is that
Can you,
Arbery reached for the gun.
Disassociate yourself
And so
from whatever
that's,
you saw
that
on
becomes a
or any
complicated
commentary
question
may
there,
have
too.
been, and
But
decide
the
solely
only
on
reason
the
why I
basis
would
of
say
what's
he's
presented
wrong,
to the court.
and this one is different from this one,
Okay.
is because
Um,
you can't jump out of a car and try to stop somebody with the weapon. That's now you're the initial aggressor. As soon as he did
Any
that,
reason this lady
you've
should
lost
be
all
excused?
your claims of self-defense. And now Ahmaud Arbery trying to grab the gun. It's a different scenario because you didn't hear this guy's an active shooter or something like that. Somebody's trying to physically stop you with the gun.
Yeah.
Now you've
No, we
lost
were-
all, I think, your claims of
And how
self-defense with
about,
that.
And we were discussing this case,
number
I mean,
40,
like
would you come
9
up,
months
please?
ago. And
Yeah.
a lot more has come out since it. So But I was just pointing out, like there can be competing viable self-defense
Oh, yeah.
claims. Both people can be justified, and people seem to think it's one or the other. It's no, they can. It's the question is literally not at all about what the other person's justification for their actions may be. It's what you did, yeah. Massive Damage Gaming says, if Kyle's defense fund gets completely drained, do the lawyers just stop working? You keep mentioning this over and over. What happens if Kyle's defense fund is drained? No, no, lawyers have to ask permission from a court to withdraw from a case. And if it's significantly far in the case, and they say, we're not getting paid, that's not justification.
Yeah, you gotta continue on.
Okay. So what's the schedule?
You can get out as long as it doesn't negatively affect your client. If you can't get out like right at a crucial time because like, he's not paying me. That's why you get retainers and hopefully try to make it so you can get past those points.
And,
closing arguments tomorrow. Your Honor, I'd like to withdraw.
I'm sorry, that's free money for him today because you gotta continue on.
The worst case of that ever is Miller. U.S. v. Miller, the Second Amendment case in 1939.
Does he live close by where he would have
so
to
the
do
guy
his transporting?
died. Miller died.
I mean, if he
and his
you say he has to
estate,
get off work,
like a week
does he work here, Tom?
before Supreme
Is
Court
the school
oral
here, Tom?
arguments, the estate didn't pay the attorney, and the attorney withdrew right before oral arguments. So the U.S. v. Miller, the landmark gun case up until Heller, was decided by solely the state making the arguments.
Thank you.
There was no.
Oh, wow.
The Supreme Court actually allowed the attorney to not
on that last
appear.
one? Incidentally, was there anyone else
That's
who was
strange.
down here in
That's
the
very
area
strange because usually they
between,
could have
let's
said no
60
and forced him to come.
65th Street and
He was put into office by a Democrat.
okay. Anybody
But that
else,
was 50
in the last
years ago,
question
Democrat.
Was
Maybe a different Democrat. What is it? Is it?
If you've
He's
ever
on a
formed or
lifetime
expressed any opinion,
appointments,
no,
though, right? He's had to be
or
reappointed.
express any opinion as to
Yeah.
The
innocence or
federal
guilt
law
of
are
the
lifetime
defendant
appointments.
without
Let me
hearing the
see.
evidence. What's your number, sir? 17, and what's up?
My biases go back to 14 months ago. I've been commenting consistently on news feeds and Facebook. It also goes a little further to my belief in the Second Amendment, which comes from Monroe's writings in the Federalist.
He's
I'm gonna
gone.
stop you.
This guy is gone.
and but here. No, I'm going to tell you. And you haven't done a single thing wrong. But
you're gone. Get out.
as I said before, if I didn't say it, I'll say it again. This is not a political trial.
I
One
mean,
of the problems with the way the media has covered this, and it's not just the media. It was mentioned by both political campaigns and the presidential campaign last year. In some instances, very, very imprudently. They're important issues for those who seek to lead our country to discuss.
The difference is the
innocence or
judge
guilt
doesn't
of an
want it to
individual
be
accused of
a
crime
political
is not one of them.
trial.
And
That's what
also,
he's saying.
the trial is not
I'm not
about,
running this as a political trial.
to the extent the trial is about the Constitution, it's about the right to a fair trial. And I don't want you to take this as a lecture. My point is that we don't want to fall into the trap that many
I
of the
write
media
about the
have, a
Constitution
large
going back to the
percentage
words of
media,
Monroe.
and discuss this as a political trial, or that there are bigger factors than this case at stake in this trial. We're concerned here in this courtroom to try this case in accord with our law, what our law provides, what our rules of evidence prescribe, which have developed over hundreds of years to improve the level of fairness. The jury system is a wonderful system that was given to us by our founders. It hasn't always worked perfectly. And in fact, there's some very shameful chapters in the history of juries' determinations in this country. But I've been in this business for 50 years. And it's getting better. It's a lot better now than it was 50 years ago. And if we keep at it and
50
try
years.
to contain our
Can you
feelings and
imagine?
decide
He
this
has
case
been on the bench
law
for
and
50 years.
unfairness, it's going to get better yet.
That's crazy. That's
So I
crazy.
want this case to reflect the greatness of Kenosha and the fairness of Kenosha. And I don't want it to get sidetracked.
no, he
with other
hasn't.
issues. Now, I don't care about your opinion.
Morpheus says he was appointed in 1983 by a
that are
Democrat
directly
governor.
contrary.
I think he might be kind of centrist.
One of the beauties of the
All
jury
I know is I
system, although
respect
it's
his
not
ruling so
intended,
far.
is that it brings together
I'd be as
the-
kind to say
a
it varies on the
composite of
position
the
he's voting
community.
for.
And it isn't just being, a case isn't being decided on political basis. It's being decided
83 to 21
it's
is
done
40,
properly
well,
on the
38
basis
years.
of what does the law say? What are the true facts? That's what the jury decides, is what are the true facts and how do they fit together? And that comes out as a verdict. So I'm sure you'll be questioned here when we go into the private discussions. I'm sure you'll be questioned about anything that you put out on the internet or what discussions you've had, but they're not disqualifying. The fact that you've disclosed them is fine, but anybody, if you've said something about the case, we want to know about it for sure. But I just don't want to get into a discussion now where we're talking about the Second Amendment or anything like that, because this case is not about, the Second Amendment, like all the constitutional provisions, have a role in this case, but they are not the focus of this case. Okay? If I'm
He's
going
right,
on,
yeah.
bear with
He
me.
got his law
Okay,
degree
so
in
do you think
1970. That's why he
you
says in this
can be
business. He's
fair-
been on the
50
bench
years.
for about 38 years,
No,
but
I
he's
do
been
not.
a lawyer for 50.
Do you think that there are other people here who are going to be fairer than you would be?
I have no idea how to answer that.
Okay.
I would hope so.
You think you're
Wait,
biased?
what?
Yes, I do, and it goes back to the politics that you told me to stop.
No, yeah, okay. Any reason this gentleman shouldn't be excused?
No.
Okay, thank you, sir.
Go on.
Mandy Carvicka says, good morning, Nick and Nate. What's for breakfast? Whiskey for me.
Yeah, I've just had
Once
this.
again, you're talking about difficult. Do you think that,
I'd be unable to.
pardon me?
I would be unable to do that.
Do you think that there's others here who are more able to be
Oh,
fair
that's-
than you?
That's
I
like,
think so.
you're not
The
helping,
reason
lady.
which this lady shouldn't be
She's
excused.
literally
Okay, thank you.
incapable of not
That's what- but-
talking to other people about this subject.
But she wanted to get off the case, and that was her way to get off. And her being, that's difficult. You want to just hear her say, I can't do it, so you're gone. You know.
Yeah.
She was just trying to play the game. She didn't want to go. She didn't want to be on. So she's trying.
Guys,
to
if you're
get
trying
All
to
right,
get
so
out of
would you
jury
have,
duty,
raised your
just
hand and
say
answered
the
to any of the
thing.
questions asked so far?
Like, don't
Thank you very
pussyfoot
much.
around
Please
it.
take that
Like,
seat.
just say, I can't be
Okay, anybody else
impartial.
now?
I love drunk
Oh,
drivers.
yeah, excuse me.
I hope they kill more
Um,
people or whatever. Like, just say
And
the
you are
thing.
number 33.
I'm driving drunk
oh,
right
no.
now.
Okay, let's
Like,
deal
just
with the one
say it.
back. This is number.
I got a cook.
Let's see.
Oh my god! You know what? One thing I think a lot of people fail to realize, and I know I'm going to take a lot of flack for saying this, but I don't care.
Uh-oh.
The media is responsible. I think the media is more responsible for this Kyle Rittenhouse situation than anything else, because
Yes.
if they hadn't lied about the Jacob Blake situation, then you wouldn't have Kyle Rittenhouse. Jacob Blake had a knife. He had a warrant. He fought the cops. The shooting was justified. All of that, right? The media, instead of waiting 24 hours to verify, guess what? His wife was the one that called. Guess what? He had a felony warrant. Guess what? He had a knife. Guess what? He wrestled with cops. They tried to use tasers. They tried to use all this. They wrestled him down. And then when they pointed guns and said, put the knife down, he reached into the car. Now, as an officer, do you want the officer to see when he's going to pull out that car after being pointed with guns? Stop. Free. Of course not. So he was totally cleared. But the media, when they first said this, they showed the video, said he was shot in the back, and it made this big fuss, canceling NBA games, for instance. All this stuff happened, right? All this stuff happened, and it was the whole narrative was false. Then you have people now get up arms thinking, rightfully so, that if Jacob Blake was just shot in the back indiscriminately, for being black, I would be out there protesting. And I'm assuming Nick would be too, right? If the cops are out there indiscriminately shooting people in the back for no reason, right? Then you got a different story. That's what
I wouldn't be out protesting because I don't
but you understand
do
what
that.
I mean.
But I would be speaking about it. Yeah, absolutely.
Yeah.
Like that's the whole deal. You and I get the luxury of not necessarily having to protest, right? Because we have
audiences.
Look, right now we've got 2,600 people. After recess, we'll probably shoot back up to 3,000 or whatever, where we were before. We have the ability to communicate directly to more people by getting on a video than we do sitting there yelling into a bullhorn and snapping our fingers or whatever. So we have that luxury, but yeah, outside of that, it's that's the main thing. We would be speaking out against this stuff. Definitely don't want people. I don't want police shooting. I take the extremist position. I don't want police shooting anybody. And then let's let that as the baseline. And then let's go backwards from there and say, this was justified. This was justified. And let's be really critical about it, because I don't want the state executing people in general. So yeah, if the police are out there actually indiscriminately shooting people, Jacob Blake would have been a terrible example of this, right?
Yes.
Like the Rashard Brooks case is better than the Jacob Blake case, and I don't think the Rashard Brooks case is all that good either.
Yeah,
right.
Well,
like,
I think
he
fights
a cop, steals the taser, shoots the taser at the cop. Other cop shoots him. I mean, I don't want a guy to die, but okay, go ahead.
No, you're right. Rashard Brooks is that cop was justified too. Right. And that cop was justified. If you base off what the damn DA said the week before, just so everybody understands, in Georgia, a taser is a deadly weapon. And they've actually had cases where people have been tased to death. So they consider a taser as a deadly weapon, as a gun.
Like a month before Rashard Brooks, the DA who prosecuted who brought charges against the police officer made this argument in court like a month before Rashard Brooks. Sorry, I didn't mean to step on you.
You're right. No, you're 100% right. And then Rashard Brooks happens, and now all of a sudden the taser is not a deadly weapon. So, it's obvious that case should be thrown out. I mean, that guy lost anyway, but he was corrupt, so he lost anyway. But anyway, this should be thrown out. In this case, though, this is what I think a lot of people don't understand about how the media can drive people to be losing their lives. Because I think if the media covered this case correctly, we don't have enough information, but we'll see what happens. And then people find out the real details. Then I don't think nobody's going to be in the street running around for this guy. Just like with Makiah Bryant, the one that was going to stab the other girl. And now you have this the mass rally for her. And she was about to kill someone else. Like, the media has to start taking responsibility for some of these things,
Not only is she about to kill someone else, she's in the downswing. Like, I'm shocked in that case that she didn't incidentally injure the person she was after, right? Because like the fact that the cop was able to shoot her in a way which stopped her behavior is almost miraculous, because you've been a law enforcement officer and a prosecutor. You could see any number of times the bullets do not stop people unless you hit them in very specific places. Movies are fake. You don't go flying back from even a 45, right? It does not launch you into the wall. They just go through you, and people tend to carry on with their activity for at least a little bit. And it's a scary situation. So
it is. And go ahead. You're about to say something.
Oh, I was just going to say, no, I fully agree with your analysis of this. The media holds a huge amount of culpability because of the way that they're presenting this. And the reason is, the media is just as click whorish as any YouTuber. They've learned this from YouTube. They've seen the success. of how you get clickbait titles, and the media has pumped this up. And following the summer of love, as some are calling it, but 2020 summer of riots and protests and Black Lives Matter, they saw dollar signs on the Jacob Blake story, and then they saw more dollar signs on the Kyle Rittenhouse story, and they were right. 100%. The media is right about how much money they were going to make. These were the Jacob Blake thing fizzled out when the prosecutors refused to bring charges, but Kyle Rittenhouse picked up the torch and ran with it.
Yeah. It gave them something. And it's just, even the way they coach. It's funny because when I first saw the Rittenhouse interview, when he was on the street, he didn't seem to me to be some racist maniac who was out there to kill black people. He was some kid who wanted to get involved, who, got a gun, had some training, and was out there running around, playing hero, right? That's fine. Now, I do understand it's a dangerous situation, and maybe he was unprepared and didn't understand the gravity of where he was at, but that's what I saw. And really, even when you look at the event, you see this 17-year-old kid, 17 really, running away from a grown man who's throwing something at him with gunshots behind him, right? Think about if you were 17 and you were in that position, right? What would you be thinking? Yeah. And I think people have to really, and that's what I think this case is going to come down to. Was it reasonable for a 17-year-old kid running from people shooting at him and another man who's throwing stuff at you, and then you get cornered and that person lunges at you trying to grab your firearm? I don't see how you don't get self-defense with those facts.
Here's the crazy thing. So many times you see, well, Kyle shouldn't have been there. He shouldn't have been out there. If you're going out there, you're entering. Okay. Let me just agree with you. Because I got 5 kids, right? You're not going to catch me at a protest because I don't want to catch a stray bullet. I don't want to catch a knife, something like that. I don't want to get knocked down, hit my head. Look, protesting is a younger man's game, and that's great. I'm not besmirching anybody or shaming. You just probably won't see me out there doing it. But at the same time, saying he shouldn't have been out there. Well, by definition of the curfew order that you're citing for he shouldn't be out there, neither should anybody involved. So we're still in the same equal legal footing for literally everybody out there. And when you have equally situated participants in an act, you don't get to say, well, one person's not justified because they were participating illegally. It's like, everybody's at an illegal poker game or something, and one guy was cheating, and the other guy called him on it. It's like, well, you can't call someone on cheating because it's an illegal poker game. That doesn't make any sense. Like the bounds of what they're doing put them on an equal legal standing. And again, should Kyle have been out there? I think Kyle would be the first to argue, I wish I wasn't there, right? Like, I wish I didn't have to go through this. I wish I didn't, I wish I hadn't had to shoot these people. But at the same time, go ahead.
No, you're right. You're right. I don't think there's any way that you can say that this kid wanted to shoot those people. But I think people have to be, I just think people have to be reasonable and understanding with how self-defense works and the situation it was in. If you really think of it as a 17-year-old kid playing hero, that doesn't excuse him from what happened. But, and I know this is going to be tough to say, I think the kid used some really amazing restraint in pulling that trigger because, from what McGinniss said, the first guy reached one time, Kyle moved back and pulled back. The guy reached again, and then he lunged like this. And that's when Kyle shot. I would have shot that guy as soon as he came kind of close, right? And maybe I'm just too scared. Otherwise, but it just didn't seem like reasonable to expect this kid to allow this guy to. And what is this maniac going to grab the gun and do to you? I don't know. It's just, and I don't know why the media is spinning it the way they are. Check this out. I'm gonna screen share something. This is the New York Times. I'm gonna look at this. This is the fatal night in Kenosha, right? This is what the media. This is what happened for the first shot. Check this out.
Let's check it out, right? Rittenhouse walks towards a parking lot where cars are being vandalized.
So this is Rosenbaum behind us. So he's just walking away from
He
Rosenbaum.
passes Joseph Rosenbaum, who was fighting with the armed men at the gas station earlier.
Who is fighting?
Now here it is.
Rittenhouse, and throws a plastic bag that holds his belongings from the hospital.
Now, mind you, he just got out the hospital too for some mental issues. So
Right.
Close behind them, a man holds up a handgun and fires it. We don't.
now I'm just stopping it here just for that. Rittenhouse is under those circumstances. Under those circumstances, do you not think that this is going to be a little that you should be it just boggles the mind why they brought charges on this, right?
The other context is I saw the judge's mug, so I was just making sure he wasn't saying anything important. The other context of this is not only did someone shoot prior to Kyle, which if you're running away, right, you're running away with a gun, you're being chased, someone shoots, you have it might be the guy behind you. But interestingly, so it wasn't Rosenbaum. However, it was the guy that Rosenbaum was with, and that's been confirmed by other video. First of all, credit to the New York Times for actually doing a really good breakdown of the timeline here that was relatively honest. Because whatever other commentary they've done on the case, like this timeline came out pretty early and was really good.
Yeah. We can watch the rest of it because after this,
Don't know why. Then Rosenbaum lunges towards Rittenhouse. Rittenhouse fires 4 times.
Had I been in his shoes getting chased and then I heard a gunshot, I can't say that I would have done anything differently.
And I don't think, and this is the part I would say, I don't think any reasonable person, because that's the standard. What reasonable person wouldn't have done what happened here? I'm talking about honestly, right? So I don't see why do you charge this kid? Why do you charge this kid and make him pay all this money and do all this for something that I think is as clear self-defense? This is what self-defense is meant for, right?
Yeah, now maybe charitably, right? Charitably, maybe the prosecutor charges him with the shooting of Huber or Gage. And again, the Rosenbaum shooting to me it's the most justified. It kicks off the event for the rest of the evening, in my opinion. And I think they're all tied, right? Like from the moment he's running from Rosenbaum, once he makes the shots, he circles back to like Jim Psaki to see how Rosenbaum is doing. And then he makes the decision, I need to get away from here, get to police. So he runs, and then he's kind of accosted and followed on the path, and he gets interrupted. But even if you think, okay, Huber and Gage, maybe he's not, the Rosenbaum shooting seems justified. And I don't know why, if you want to prosecute on the next 2 shootings or 3 shootings, because he does miss the one guy, but if you want to prosecute on the next 3 shootings, why would you include this one as like a predicate act? Like, because it's going to get brought up. And I personally, like I said, I think psychologically, if you win the Rosenbaum case for the jurors, you win the case.
I think you're right.
But they could have made some decisions. I don't know how, because to me, all 3 shootings are clearly justified. But I could at least say, trying to make some wise discretion, say, no, we actually, and that'd be a good psychological tactic. No, we think he was justified here. However, we think his actions in the following incidents were so egregious that they passed the bounds of self-defense. To me, it's like the prosecution has hamstrung their own case from the get-go, starting with the complaint itself.
Yeah. Oh yeah. Here's their last 2 shootings.
Falls. And Rittenhouse trips and falls. Anthony Huber hits Rittenhouse with a skateboard.
Now this guy kicked him, and now he getting hit with the skateboard. But this is now
and attempts to disarm him. Rittenhouse.
Now that's where he's grabbing the gun, running away, and he pulled the trigger. That's where
shoots him in the chest.
Now look at this
guy.
Here
is Gage Grosskreutz with his gun drawn.
Now I want to scroll this back 1 second. Look at this part here. Oops. Kyle Rittenhouse
Disarm him.
Let's see if I can
Rittenhouse
do this
shoots him
one.
in the chest.
Now, see the last guy, the guy who lost his bicep now to a unicep, but when he puts his hands up and walks back, and then he lunges at Kyle, and then Kyle then puts up and points the gun and then shoots him then. So even in that situation, Kyle wasn't going to shoot him. He put his hands up and moved back. Kyle's getting up, and then he lunges at Kyle, and then Kyle shoots. So here, and he has a gun in his hand. Again, as a reasonable person,
Yes.
I don't see how you don't get self-defense here. I just don't. This is self-defense 100%, right?
Wouldn't it be great to have those young man reaction times? Like, because that's the one thing these videos don't do, because they're focused on explaining, like they pause and they highlight stuff. What was it? John Black, right? The expert. He says that the shootings here that follow, it's 7 seconds of time.
Yeah.
Between Huber coming at Rittenhouse with the skateboard and him shooting both Huber and Grosskreutz. It's 7 seconds. It's so fast. And you're right. Gage lunges back for Kyle, which is just dumb that he does that, but he makes that decision. And it's entirely different between one of my other favorite non-self-defense cases, which is Michael Drejka. He's the handicap parking spot guy, right?
Yeah.
He actually gets knocked down. He pulls the gun on the guy, and the victim of Drejka was actually stepping back and turning away. And the video shows that he had made the move backwards and away. And of course, the bullet trajectory is through the ribs sideways rather than front on, showing that again, he was turning away. Grosskreutz is not turning away. He's coming forward. He's pulling his gun up. And it's a mess. And anybody who happened to see that, if Kyle did not pull that gun and shoot him, it's every likelihood that Kyle would be dead. And that is quintessential to the question of, would a reasonable person feel they're justified to shoot in this situation? Yeah, of course. Someone's about to pull a gun out and shoot you, and in your mind, all you've been doing is defending yourself this entire time.
And I think the key point here also too is, if this guy puts his hands up and starts moving backwards and Kyle shoots him, you got a whole different scenario now, right? You got a whole different scenario. But when he did do that, Kyle didn't shoot him. And then you'll see even after this, somebody else is coming forward and Kyle puts his hands up and Kyle doesn't shoot him.
With his gun drawn. He also gets
last
shot
guy
and calls out for help.
Yep.
The reality of it is,
Yeah.
That's
So
very
they got-
unfortunate for Grosskreutz.
Yeah. But now I do want to say this too, because now since we're talking about the legal reality of this, I want everybody to understand. Grosskreutz and what's the guy that Huber with the skateboard, they have viable claims for self-defense too.
Right.
And I'll say because they believed he was an active shooter. So just imagine if somebody's like, again, like I always make the excuse. Let's say if you're in a building and somebody says, "Hey, there's a guy around shooting people," and then you see somebody with a gun, and someone says, "That's the guy who shot the people," and you have weapons on you, a gun. Do you shoot that guy? And if you do, was it reasonable? Because you've heard the gunshots, you see people screaming, he's shooting people. Is it reasonable for you to take that guy out? Would a reasonable person have taken that guy if they had the tools to do it? And I think in this case, even though their beliefs were mistaken, because they have mistaken belief that Kyle's an active shooter, the law even addresses that and says, even if your belief is mistaken, if it was reasonable at the time, then you can use self-defense. So at this point in time, if Kyle kills him, Kyle should be justified. But if he kills Kyle, he would have also been justified in killing Kyle, which I know is a little weird for people to really understand, but that's the way the law is. Am I wrong?
No, I think you're right, so long as both Huber and Gage actually possessed the subjective belief that they were acting in self-defense. That's the trick. Now, we don't know.
Because they weren't after.
Or
they
defense
weren't
of
after.
others.
Yeah.
Right.
Go ahead.
Now, if we won't know Huber, right, because he's dead, so we can speculate. And Gage is likely going to argue that he believed he was trying to save people or whatever. This guy was a menace and a threat. And yeah, they could make that claim. I think the objective reasonableness is there. but it's the subjectivity that is the key, and that would all depend on what statements they made to police following the incident, typically, because that's how you're going to garner the subjective nature of this. Is what do they say when they're cross-examined? What do they say to police officers in their recorded interviews? But yeah, so subject to those caveats, I agree. I think they could reasonably make those claims if they have the subjective belief. Now, if they go, this is some guy defending the car lot and he's a piece of garbage, I'm going to kill him. Like, that's obviously right. Obviously not the case.
Yeah,
but
I'm just assuming that these people, because if when you hear the story, everybody's saying he just shot some people, he's an active shooter, that type of thing. Then I think that changes that formula. But again, you know, it's a weird little situation to be in. But I think everybody's just focused in on, you know, when Kyle killed these people, what was his intent? I don't think he had any intent to kill any of these people, right? And that's another thing, that they're charging with these intentional murders or negligent murders. Doesn't have that intent. He's trying to get away, and these people, unfortunately, are preventing him from doing so. So, you know, this is a really tough case. But if I will just say personally, if he is convicted and his self-defense claim isn't upheld, I think that would be injustice. So it just is.
And I think we'd have an issue, because the first time I saw this, I was like, this is self-defense. I mean, I don't know how you write a self-defense. I mean, if Zimmerman is self-defense against Trayvon Martin on the rather thin factual basis coming from the only living party in that case, if Zimmerman is self-defense, I have no idea how Kyle is not self-defense. And so I think you're right. If he gets convicted and it's upheld on appeal, I think we've got a real issue with the basic common law idea of self-defense in Wisconsin. And I think Wisconsin would have something to work out there. I hope he doesn't have to go through the appeals process to show his innocence, because in this one, it's like, I can't imagine anyone other than some like avowed pacifist doing something different in this situation.
Well, because when self-defense, a lot of these cases turn on the whole, what would have happened if he didn't do what he did? Right. So with the first guy, what would have happened if he didn't pull the trigger? Well, then that guy, this mentally ill person, which Kyle probably didn't know, so you probably wouldn't even be able to use that. But you would say, what would have happened? Well, he would have grabbed that gun. And then now is Kyle's life in more jeopardy or less jeopardy? You know, now you're struggling over a gun. And the good thing is the law doesn't say you have to put yourself in that position. The threat of being in that position, the imminent threat of being put in that position, allows you to respond, so you don't have to be struggling with somebody with the gun. I think Rosenbaum is done. The second two, I also think are self-defense, but I think you also have that issue where you have competing self-defense claims, and I just don't think any reasonable jury can look at this video, understanding the full context of the circumstances, and come to find this kid guilty. Especially after what McGinniss says. McGinniss is one of the witnesses, and they have him. Let me. You want to see his interview? What he says about what happened, and because
if you got it, that'd be great. I'm going to read the super chat. Peter Bemis says Grosskreutz would be guilty of a war crime in a war zone. Feigning surrender in order to inflict harm is internationally recognized as criminal. It is only in war, though. That's kind of a weird artifact of it. You're right. In a war zone, that would be improper activity, but they're not actually at war there. McGinniss he's a journalist for PJ Media. Or is it Gateway Pundit?
The Daily Caller.
I can't remember. Oh, Daily Caller. Okay. So so he's a right-wing commentator, sorry, I shouldn't say right-wing comment. He's a journalist for a right-leaning publication. That's probably the more appropriate way to say that. Yeah. He's a journalist for a right-leaning publication, presumably on Kyle's side. They use his statements for the majority of the complaint, like his witness, especially as in regards to Rosenbaum, I should say. His witness statements as the firsthand person who is closest. He's the guy they rely on to write the complaint, which is why it reads so favorably for Kyle in those first instances. Okay, let me pull it up here.
Well, but two things, though, with McGinniss. Number one, they're charging Kyle with putting McGinnis's life in danger because McGinniss was behind the guy that Kyle shot, Rosenbaum. So they're saying that by shooting Rosenbaum, he also put McGinnis's life in danger. So that's and McGinniss is the one you'll see when he's the one that took off the shirt to try to save Rosenbaum's life. But this is what this is McGinnis's present sense impression of Kyle at the event was. So let me play this.
Yeah.
He did say that there was a lack of law and order in the area, and that in the absence of police, that he was providing that. He also mentioned that he was a certified EMT, and that his primary goal there was to provide medical aid to protesters. So it was very clear that he had an idea in his head that he was there to help, both for protection of the business and of just the people in general there, but also to render medical aid to any of the protesters who were injured. But the real thing that I picked up on after that interview, I thought to myself, this kid he's very innocent. I don't think this kid realizes exactly where he is. And once I saw him being yelled at after I'd interviewed those other individuals, just prior to him basically running and the whole thing happening, my final thought was, oh my God, like this kid does not realize that all these people are looking at him and screaming at him. And these people are ready to go and grab him. And it was at that very moment that the man who was shot kind of ran towards him, and everything unfolded from there.
All right.
Now, the interesting part is in the complaint, he goes on to say how the guy was grabbing at Kyle's gun and lunged at Kyle's gun before Kyle shot him. So, I don't think this is a good witness for the prosecution, right? I don't think McGinniss is a good witness. I don't know. I don't see how you put him on the stand and try to get a conviction from this guy.
Right. It's weird to me that they're charging the reckless endangerment basically of this guy
for McGinniss,
because because the prosecution's gonna call him, which means the defense is gonna get to cross this guy, and he's gonna go with the defense's narrative on this 100%. And he's probably going to give some troublesome, testimony to the prosecutors. If you guys don't know, when you're calling a witness for your case in chief, you ask open-ended questions. You're not allowed to lead the witness. So you have to ask questions to elicit a narrative from the witness's perspective because they're presumably favorable if you're calling them. So prosecution's going to call this guy to talk about reckless endangerment stuff, and it's going to lead into everything else. And he's going to say, no, I actually think Kyle Rittenhouse is justified. And then on cross-exam, you get the opposite job. You can ask the open-ended questions. It's not generally recommended because you get to build your narrative by leading the witness through things. And the witness can be limited to basically yes or no answers. So you're going to ask this guy, hey, was Joseph Rosenbaum chasing Kyle Rittenhouse? Yes. Isn't it true that you saw him reach for Kyle Rittenhouse's gun? Yes. Isn't it true that you believed at the time that in this situation, Kyle Rittenhouse was in danger? Yes, I did. I had that present sense impression. Do you think it's reasonable for someone else to have that impression too? Yeah, I do. You get to ask questions like this. And that's why this witness is going to be it's such a weird thing, because if you don't charge the reckless endangerment, right, then you force the defense to call this guy as a witness. You force the defense. Yeah, and then the prosecution gets to cross him, and they get to build the narrative that way. And it's still going to be rough, but not as bad. So in my opinion, a very weird charge on this one. And they're basing it, from what I can tell, on statements that he said that once Kyle fired into Rosenbaum, something hit this guy's leg. And he thought briefly that he had been shot. He doesn't know if it's debris or from shrapnel from the gun or a piece of concrete that popped up and hit him. He has no idea. But at first, he very briefly feels, oh, maybe I was shot. And it's like, that doesn't put him in reckless endangerment. That leg pain could have been anything. It could have been psychosomatic. It could have been a chipped piece of concrete. It could have been something completely unrelated to this. And so, again, a weird and thin claim by the prosecution on this one.
here is the one thing. Now here's the complaint for everybody, the criminal complaint. It's still up on the screen, right? This is reading through this for those of you who don't know. I'll put the link in the chat too so people can read it. But one of the things is that on this, when they talk about McGinniss, and they lay out the facts for McGinniss, they say, where's it right here? About here the Lord Bing F you. Then McGinniss, then Rosenbaum appears to continue. Sorry, let me read from here. I'll highlight it. It says F you. Then Rosenbaum appears to continue to approach the defendant and gets proximate to the defendant. When 4 more loud bangs are heard, Rosenbaum then falls to the ground. Defendant cries, help, blah, 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 blah. I just killed somebody. Where is it at? Here it is. McGinniss stated that as the defendant was walking, Rosenbaum trying to get close to the defendant. When Rosenbaum advanced, the defendant did a juke move and started running. So he got it. So Rosenbaum has been after him. McGinniss then stated that there were other people. McGinniss then moved to the defendant, approaching when he saw. I'm trying to get the part where he says he lunged at him and grabbed the gun. Here it is. McGinniss stated that he did not hear the two exchange any words. McGinniss said that the unarmed guy, Rosenbaum, I like how they put unarmed here, was trying to get the defendant's gun. That's damning, right?
Mm-hmm.
McGinniss stated that the unarmed guy was trying to get the defendant's gun. That's damning. That's like, why are we bringing this charge? Then the next sentence closes the door. McGinniss then demonstrated by extending both hands in a quick grabbing motion and did a visual on how Rosenbaum tried to reach the defendant's gun. Game over, right?
Why is this in the complaint?
Like, okay, self-defense, right? Game over.
Yeah.
Why do you this? And this is not the defense's thing. This is the complaint of the prosecution.
Yeah, would you,
How
as
is
a
this not game
prosecutor,
over?
would you ever write that in a complaint?
No. This is
Because
a self-defense complaint. This is that's obvious self-defense. He's giving for the gun. So
You got 2 options. You either don't charge or you just don't mention this very inconvenient fact and you force the defense to raise it at trial. Like there's no middle ground. This is a terrible thing to include in the complaint. Real quick, there's someone in the chat who has an interesting legal take that I wanted to get your opinion on. It's from Butterfly. He says, Kyle did not have the legal duty to protect the dealership. That is the duty for the cops and or the National Guard. Do you have any opinion on that?
It's irrelevant.
Thank you.
It is irrelevant. And I don't mean to be dismissive of it.
No, you should be.
But
because Castle Rock v. Gonzalez, right? Castle Rock v. Gonzalez. The cops have no duty.
No duty. Yep, the no duty case. But that was just Scalia's opinion, which I think is a brilliant opinion. You guys should definitely read that, the Castle Rock opinion. But in this case, if Kyle, as a citizen, if he's holding a gun and walking around and the police aren't arresting him, right? He has the same legal right to be there as everybody else. Now, you can make an argument that everybody's violating curfew, but then again, we talk about being selective here. You got all these people out there walking around. The key issue is, even if Kyle had run into a bank with the gun, is he justified in running away from this person? Because every piece of evidence we have is that Kyle was trying to run away from the contact. You heard the eyewitness who was there with Kyle saying people were after him. They were trying to grab him. He fled the scene, and this guy ran and tried to grab for his gun. Those are the key facts here. The fact that even if that gun, and I'll go to the extreme example, even if Kyle was a felon and that gun was illegal and he had illegal ammunition, we can make that everything about that gun in that situation illegal. That does not remove his right to have self-defense. But now I want to make it I do want to make it very clear, because then you're going to have the people say, well, what happened if he was robbing the bank? All right, if you're the agitator, right? If I go into a bank and point guns at people, freeze, give me. I have now initiated it. I am the agitator. So I'm agitated. So now I'm the provocateur, as they call it. Now I don't have a claim to self-defense because I'm the one pointing guns at you. But if I have a gun and you come at me and start throwing bags and I'm running away, obviously you are the one, the antagonizer. You are the one provocative. And then if you put me into a corner where I can't leave, right? Because he's trying to run away, but now he's cornered. Then you have a classic self-defense claim. That's what makes this different. So yes, even though if he was breaking the law, he was violating curfew, but that does not absolve, that does not remove his right to self-defense in that moment. Excuse me.
Yeah, and very, very well said. And it's something that bears repeating. If you're in the bank, like if you go to rob the bank and you change your mind and you pull up your gun and you run away from the bank and the bank security guard chases you down and you say, hey, no, I'm sorry. And the guy then pulls the gun on you like you're a block away. You may actually be justified in shooting that guy because you're no longer engaged in the first aspect, that agitation. That's in the Wisconsin law, that if a person retreats and they clearly communicate that they're not engaged in the initial aggression, then it resets the self-defense claim. Yep.
Yeah.
And so it's important to note that that Kyle, by all accounts that we can see, was retreating, even if he did or didn't have to. That's irrelevant. That because it's mitigated by the fact that he did retreat, whether or not he had to. And then the other interesting thing is, for every duty to retreat state that I'm aware of, Wisconsin is not a duty to retreat state, but assuming he's the aggressor for the purpose of argument, and then thus assume some need to retreat, in every duty to retreat state, the legal standard for when your duty to retreat ends is when your quote back is against the wall. And basically, and basically all of those courts recognize being on the ground as the equivalent of having your back against the wall. Once Kyle is down on the ground, whether he was knocked down by Huber or someone else, he was kind of hit at first, and then he falls. Yeah, he falls a couple seconds later. So whatever, it doesn't matter the justification. However he ends up falling, either through his own act, through someone else's act, he is no longer capable of retreating under the law. And at that point, his duty to retreat has ended the moment he hits the ground. These are all really important nuances of self-defense law that a lot of people saying that Kyle is guilty don't seem to understand.
Yeah. And I know that there are going to be riots in the streets when he's eventually let go, right? We know that the summer of love is going to start again. But
be a mess.
It's going to be because people are just uneducated in what the prosecution is actually doing and what the law actually is. Because I don't think any fair-minded person, liberal or conservative, can read this complaint and not see it screaming self-defense, because they're key witness in this thing, right? The person who was there is saying, yeah, it was pretty much self-defense. The guy was lunging at Kyle's gun because this maniac was chasing him. He waited to the last possible second to shoot. But it then makes you think. The scary part about this is, why was he even charged with this first crime, with this first murder? Reading this, there's no way he should have been charged with this.
Yeah, it's such a tortured writing of the complaint. And again, when I got it, I remember I was down in Florida. I was at my parents' house. And so I'm on mobile and I'm like waiting for this thing to come down. I read it and I'm like, you got to be kidding. This is the most tortured complaint they could have written. It would have been easier just not writing it. But I think taking the charitable approach, the most charitable approach, not going with my full anti-government thing, but just in general, I think the prosecutor felt immense political pressure from publications, especially in the context of the riots going on, and he thought maybe if I'm being charitable, he thought if we just prosecute this thing, maybe we can calm people down. What do you think on that?
Possible. Yeah. I agree. I think this may have been don't forget, this prosecutor's probably, got an elected official, and I'm not sure if he's Democrat or Republican, but if you're a Democrat, that puts even more. Oh, so that puts even more pressure on you, right? Because now 80% of your base believes that this kid is a racist guilty, right? So what you want to do is get the targets off your back by saying, okay, we prosecuted him and the jury You know, the legal system didn't. Maybe we need to change the law in that particular sense.
Yeah, I did everything I could.
Yeah, and I think that's what this guy's trying to do. He's trying to kick the bucket down to the jury. But I think the strongest thing to do, and I think the more appropriate thing would have been to do, was to not bring these charges at all. But that takes too much political courage, right? Because again, he's got a family to feed.
It is for him probably political suicide to not bring these charges, especially on the heels of Jacob Blake not having the charges brought against the officer who shot Jacob Blake. The most amazing thing of the aspect of these, Jacob Blake, I believe, avoided all of his criminal prosecution, didn't he?
Yeah.
This man was committing like 4 felonies at the time.
And one time, and don't worry about it.
And it's got all the focus became on the police officer who shot him, and it's like then that's gone.
But you couldn't get a conviction. Do you think they really would have been able to convict Jacob Blake, even though he had all those felonies? They wouldn't have been able to convict him.
Not after the shooting.
Yeah, that's what I'm saying. I don't think
the shooting is.
I don't
like
think you
the
get
jury
the jury
goes.
to convict him.
Okay, but he got shot
enough.
though, and he's in a wheelchair for the rest of his life. This
Yeah.
guy's not. Yeah. But then the other thing is in the Rittenhouse case, again, you have tons of people involved who otherwise are committing felonies, or at best, some pretty serious misdemeanor crimes, right? Like,
well, all of them are violating curfew. All of them are violating.
All of them are violating
curfew.
curfew.
Yeah,
and that's I hate curfews in general. I'm not going to defend any curfew ever.
No, we're not defending it, but we're giving the legal reality of they were violating curfew.
Yes. Although here's a question for you, and this is a legitimate question. I don't know if Kyle had not left the car lot. Is he violating curfew?
No, I don't think so.
Yeah, I think that's
an
interesting
property. The curfew is not about being. It's about being on public streets. As long as you're on your own property. That's why a lot, and that's one thing a lot of people didn't. A lot of the people on the left don't understand is that they're saying like the people with the guns, all of them were violating curfew. Well, if those businesses said, "Hey, we want you to protect our businesses, stand on these. You can stand on our property." Then, if you're on that property, you're not violating curfew. It's when you go onto the public streets, then you're violating curfew.
Yeah, and that's a critical distinction in this case, and an interesting defense. And the defense has hinted that they're going to be bringing these types of things up, right? Like they're going to be bringing up the fact that Kyle Rittenhouse was there that night, not necessarily at the time of the incident, but that night to defend. He was under the reasonable impression that he was defending a particular piece of property, and he was under that impression that the owner had given his permission for him to do so. Is going to be a big part of this, because some people are out there like, oh, he's a roving vigilante out on. It's like, no. Like specifically asked, according to the things I've read, and maybe I have not read everything, which is likely, but according to things I've read, his friend says, hey, we've been asked to go hang out at this property, make sure the rioters don't come and destroy the cars. You in? And Kyle says, yeah, I'll be there. That at that point, he's under a pretty reasonable belief that he's going to be able to be at this place and not be in knowing violation of a curfew. Because you could be on private property all day. Like you can stand on the edge of your lawn during curfew and pee into the street all you want. Yeah.
Yeah.
As long as no one's looking.
And New York had this stupid law, right? Where we have brownstones here. So people were like smoking weed on the brownstone. So they're saying, so the cop says, hey, come here for a second. Let me speak to you. As soon as the guy comes off the brownstone into the public street, they write them a ticket. You're smoking in public. He's like, what do you mean? You told me to come here. Well, you came out. So that, and unfortunately, curfews only have to deal with public property. They can't tell you to stay inside your house if you have a yard or whatever.
Right.
But I think all those.
They can't keep you away from other people's private property that you have permission to be in either.
Yeah, of course not. But I do think now but I think all those, I think the defense's case is so good. I don't think they need to go. I wouldn't want the jury to be confused about shit. I'm like, yo, let's just keep this as simple as possible. McGinniss, as soon as they call McGinniss, he's a virtually eyewitness. It's a free witness. McGinniss, what did you see? Have him play, and if he says anything that differs from any of this stuff, we destroy his credibility, right? Well, in the complaint, you told the cop this. On these interviews, you said this. So now you're changing your story. McGinniss is done. That's our witness. Then the other two, this is done. I'll be shocked, but I've been shocked before. I'll be shocked if he's convicted.
Yeah, I think the most promising aspect of this so far is that the judge has been very level-headed. He's and his motion rulings are not ridiculous. Like there is a situation where you could see the judge ruling differently on a lot of these motions and still like maybe not be horrific, but the judge has been pretty consistent on this. And I think the biggest win for the defense was the concession by Richards to limit John Black's testimony. But the judge seemed already keen on doing so. Like, I'm not criticizing the defense in making that decision. The judge seemed like we're going to pretty much keep John Black to his expertise on the video itself. And that's it. The defense, I think they might push for a little more. They might try and get some behavior opinions out of him as part of his expertise. But in general,
that's going to be tough.
Yeah, but that's the biggest win the prosecution has gotten so far. They've lost on everything else, and the judge is reasonably applying the law, and I think the prosecution knows it, right? I haven't seen any press conferences from Binger talking about how like they're really having some questions about anything going on. They haven't motioned for the judge to recuse or anything like that. So the indications in this case so far are that both the prosecution and the defense think the judge is acting fairly, even if things aren't going their way. And that's good news. Again, that's what you want. You want a judge that you can is going to be consistently predictable one way or the other.
But Nick, let's keep it 100. The prosecution has a shit case.
They do.
And the judge,
they do.
And let's not pretend the judge doesn't know this, right? The judge knows. The judge just read this complaint and said, "Oh my God, are you really bringing this case?" You know. So these rulings, I'm thinking, are really letting the prosecution know you're really going to have a hard time here, because why are you calling him a victim when your goddamn key witness is saying something the guy's grabbing for the gun? Obviously, it's going to be even more prejudicial calling him a victim when he's the one agitating the guy. So no, let's not call him a victim because it's unfair, especially with the facts we got, right?
My favorite moments so far in this case was when the judge was arguing over whether or not the impacted people could testify in the case, right? And the prosecutor says, "Well, Anthony Huber and Rosenbaum won't be won't be able to testify in this case." And the judge's reaction to that moment is, "Do you have any other point to make?" It was just like his veneer has cracked a couple times, and you're like, I think you're right. The judge has read this complaint. He's like, I mean, okay, I got to be impartial on this, but we got to also face the factual reality. And that's the thing with the looters. And he's like, if they can demonstrate that these guys are burning things, calling them arsonists is pretty fair. Like, please.
Yeah. If they're on camera burning stuff up, but I don't think you don't have Rosenbaum. I think is the one that you might have a little something with, because he was just, I hate to say escape mental patient, but literally he had just gotten out of a hospital for mental issues. And and that's why that bag that he threw at Kyle Rittenhouse was literally, they put all his clothes in the bag at the hospital and gave it to him. Yeah. And he runs to a Black Lives Matter protest with all his clothes and stuff in his hand.
With the bag. He's literally
it was a hospital bag.
Hospital. Oh, it's the insanity of what was happening there is beautiful.
I was going to show you the part again, because it's not what any reasonable person would do. We're talking about really what a reasonable person in Kyle's position, really 17 in that particular space. You know, it's just like, you know, if
I think a lot of reasonable people
of the
Summer of Love.
Yeah, in the context of Summer of Love.
Right.
But I don't think there's anyone who would say them running from someone, hearing gunshots behind them, and getting cornered, and the person who's been chasing you, there's, you know, I'm assuming Kyle didn't know he was from he was a escaped mental patient, which he wasn't, but he was a mental patient. You know, I just don't see how. I just don't see. Again, it's just, and that complaint. There's something up here we're missing. There's got to be something we're missing, because there's nothing of this stuff that just adds up. It just doesn't add up. That complaint doesn't add up. This video doesn't add up. Why is this kid on trial? Why?
Yeah. Other than it's overtly political. It's hard. And I've been really trying to resist that label on this. Like I've been really
Political
trying.
prosecution.
Like, yeah. I'm just because, and I always fall back on, you got two bodies. So at the end of the day, the prosecutor can probably justify this because you got two corpses, and you know exactly who shot them. Like, you've got it on video who shot him. So there's no who done it in this case. There's no forensic analysis needed to like tenuously tie a bullet casing to someone. Like you have these hard elements of some murder cases already taken, and you've got two bodies. You know who's responsible for it. Then I guess you bring the charges and make them justify it. But I don't agree with that. But at least that's the only thing I can see, unless there's something going on somewhere else. But I try not to engage in conspiracy unless I have some ground for it. And in this one, but I think if there was a crazy high level conspiracy on it, they wouldn't have had Bruce Schrader as a judge.
Oh yeah. No, I don't think this is. I think it comes down to just apparently two people are shot. You got a heavily Democratic probably district. You know, this DA is like, yo, and you saw how hard it was for him not to charge his own cops who were clearly in the right. You know, they had to do that whole thing. And then it's like, you know, then you're running for re-election, and now you got this thing comes up. You know, and the media has all, you know, you got all the young Turks and everybody screaming, this was some wild racist across straight lines and was looking to execute, you know, protesters. And it's like, well, hell, you know what? Let's run it up and let the jury make the decision. Now, is it right to do? Is there probable cause? Yes. And I think it's fair that you can go and say, you know, let's ask people if this happens. But I think at this point in time, I think anybody reading the facts and hopefully there'll be more facts that come out in trial, but anybody reading the facts as they are, I don't see how you get not self-defense. But maybe, and I want to also coach this with this. If there are new facts that come out during this trial, my mind could be changed. You know, if Kyle Rittenhouse, you know, if they had some mic on them and said, hey, I'm going to kill this guy Rosenbaum, watch this, and goes and antagonizes Rosenbaum to chase him, something like that would change my mind. But there's absolutely no facts that I've seen now that would change my mind to make this is something that this was not self-defense.
And
did they start back up in the court?
No, not yet. I've got it here just waiting. TV has ruined this in people, but in the majority of cases, there is not a surprise fact, right? There's not like some secret witness. All the witnesses are disclosed. Their statements, they've probably been interviewed or gotten some statement from the attorneys in the case of some sort, or if they've given a statement to the prosecution has turned over that statement to the defense. All of the video in this case is going to be disclosed to both sides. So, and if it comes up, for example, that the prosecution actually had a piece of evidence, like some rock solid stuff that they were somehow trying to obscure,
we'd have seen it,
sit upon. We'd have seen it. And if it comes up at the right time and they're like, wait, you should have had this a long time ago, why wasn't this disclosed? That's a mistrial and it's over anyway. That the TV has done this where they think there's always going to be like that Columbo moment or whatever, where someone walks in and changes everything. That's not likely to happen.
You're alive. He's alive.
Rosenbaum walks into the courtroom. Kyle's like,
we thought you were dead.
Yeah, the idea that we don't that you're talking about, like, of course, you're a lawyer, you're a reasonable guy. if it comes out that there's a bunch of audio of Kyle Rittenhouse saying, I'm going to kill this guy, that Chuck Huber guy stole my lunch money last year, whatever it is, that's going to change the opinion. But the likelihood of any of this stuff happening is really low. There's got to be some crazy thing that occurs, and it's not going to be a FLIR image from the FBI drone that they, that bothered me, by the way. Did you notice that? They're like, the defense is like, they didn't tell me that this footage exists. And they're like, well, we sent you an email with a link that said that it might be there. It's like,
doesn't have arms.
Yeah.
Why didn't you just disclose the video?
Situation. And
Oh my God.
We're going to continue with the exam. You missed some of what was said this morning. Okay. Any reason?
Everybody's ear is gone. Judge, you need to say it all again.
Okay. Thank you, sir.
See, all those elaborate excuses. Let's come back from lunch. I didn't hear what you said.
I didn't hear earlier, Judge, when you said we could say what the problem was. Sorry.
Number 55.
55 is a hearing problem. You can't hear either. I was right next to 56.
Again, if you can't hear, please let us know. And also, we
Judge,
have,
you can't say if they can't
these
hear,
devices
please let
here,
us know,
and,
because they
is
can't hear
anybody
you.
actively using one right now?
What did you just
Anybody
say?
want to endorse this product? Senor Leo Martin, who is
how do you anticipate this trial realistically going?
Anything about that?
I
that would
think
affect your ability? Okay. Thank
I
you.
think having
Anyone else
an
whose
acquittal
hands I
on the
missed?
major
Okay,
charges
juror
is
number
likely.
31.
Probably eats
Okay.
it on
Anything
the
about that that would
breach of
affect your
curfew
ability?
charge, even though it's bogus.
Thank you. Anyone
Possibly
else?
on the
Oh,
gun
you raised your hand,
charge.
sir? Okay, sorry. You are juror number 50.
And I'll
Yes.
explain the gun charge in a little bit.
Okay.
We're still live, as legit as it gets. Okay, the gun charge is possible because, as a matter of
If I just
law,
could
the
have
gun
one
charge should
moment
be
to,
dismissed, in my
confer
opinion.
here.
However, if it's
you, that's
not
all I have.
dismissed as a matter of law, the jury questions are basically: is he under 18? Was he carrying a gun? That's gonna be it. Those two facts are yes. So, if the gun charge is not dismissed as a matter of law, Kyle may eat the gun charge. Gun charge is a misdemeanor.
Prefer to start
and
be interrupted
and
or
will
wait?
not be a big deal in the long run. It will not prevent him from owning guns in the future. He'll probably get a year of
Be my guest.
probation, not be allowed to own guns for that year, and then after that, it'll be done. So that's my guess on what could happen. I think it should be dismissed.
Thinking only of
I
myself.
think he should be acquitted on all
How
charges,
about
but I
you
think
folks? Anybody need a break?
the jury's
Anybody?
probably going
yeah,
to
let's do this.
probably going to stick him
Let's
on
take
the
a condensed break of about, let's hope for 10 minutes.
condensed
And,
break of
that-
10
that-
minutes.
So-
One of the charges is a violation of a curfew. Does anyone believe that if there's a violation of a curfew, that fact alone then holds them responsible for everything else that happened after that curfew?
These are good questions because there are
Anybody believe that?
legitimate morons out there who believe that the violation of
no
a
hands.
curfew or the carrying of a gun, even illegally,
I think the judge will tell you
invalidates
this. So there's
self-defense.
6 charges.
Neither
I
of
think.
those do.
Each one
Neither of those do.
requires
And
a
if
separate
you
finding
think
by you
either of
beyond a
those
reasonable doubt.
invalidates a self-defense
Is
claim,
there anyone who
then
would
you're
have difficulty
literally
separating?
fucking stupid and you don't understand self-defense law. You shouldn't be talking about it. Go try
So,
not to drown in a
curfew
bowl of
violation
Campbell
is a
soup,
civil
please.
But is there anyone that impact your ability to decide the case fairly? Would you be worried about outcome?
No. My fear is walking out of any of the days of court and just wondering what we're walking out to. What are our cars going to look like when we're going out?
Removed for cause. Get her out.
Am I going to be able to get home safe? That's scary.
Just to interject, there are measures that will be taken with the jury that is selected to deal with those fears. And I think your fears would be substantially diminished
No, strike
once you're made aware of them, but I'm not going to talk
Strike
about them right now because they're less effective if I do. So we'll leave it at that.
I appreciate your honesty. Is there anybody else trying to follow up on that? Since it's anybody else who feels that sitting on the jury, on this particular jury, would be difficult because of either the pressure, anxiety from any of the things that Juror 31 had said, fear of what a verdict might do or be, what it means to the community? Anybody here have those fears? Juror 4, if I remember this, 40 and 24.
Yeah, I think I'm more afraid of the community, and I should say all the outsiders from our community that are coming in because this is such a public case.
Got that Arby's.
Just brings it back to August last year. The civil unrest, or the possibility of the unrest and the unknowns, it just makes you feel uncomfortable.
Do you have concerns that a specific verdict could be a problem for the community?
Potentially.
Okay, so there's
Strike this lady. Oh my God, you have every reason on earth to strike this lady. She's terrible.
But that doesn't stop the politics from outside the courtroom, you know what I mean? So people are gonna do what they're gonna do. Does that make it right? Absolutely not. But I can only, you know.
how do you would it impact your ability to be fair though, having lived through whatever you lived through, however you felt about it, would that
Roscoe,
impact
you're
your
right.
ability
I am
to
the Michael Drake
judge this case fairly
I kill
because
the
of those
competition.
No. I think it's more so like she had mentioned, like what happens when we leave the courthouse and all of the unrest that could possibly be there.
But you still spammed, so get the fuck out.
Let me just tell you that I've been in this business for over 50 years in the criminal courts, and I have never, ever had any incident in any of the courts, not just in my court, but in other judges.
Stop reassuring this lady and just strike her. She's obviously not fit for jury duty in this case.
We've had some pretty person people in here over the years.
Goblin, yes, you can provoke people by lawful conduct. Go back and watch. Nate and I discussed this. I get that you're fucking idiotic and you have no brain and you can't reason through things and you can't read the law and you can't read case law and you can't read statutes. I get it. We explain everything to you. Just go back. God, you're so fucking dumb. The real question is, when you get in a car, do you have to have an assistant so you don't run yourself over? What is wrong with you?
Are you okay? Meaning, are you willing to listen to the case, judge the evidence, understanding that a specific verdict, whatever you think might bring out, as you call them, the crazies, are you okay saying, look, I'm still going to do what I'm going to follow the law.
They've spent like 8 minutes on this lady. Just strike her.
I'm going to render a verdict that I believe to be correct with all of that kind of background noise.
Yes, just because I got my own self-integrity thing. So, yes, I don't think that it would factor into me being unbiased to being able to look at all the evidence to make a decision. And it's my anxiety.
Okay, thank you. I think Juror 15. Did you have your hand up, ma'am?
All right, so she's on the defense's strike, 7-strike list. All right, guys. Catch you later. Hope you have a good day. I gotta go I got to try and troubleshoot this computer while drunk. Thank you. Thank you for that. We'll see you tomorrow. It's tomorrow morning, 9 a.m., same time, same channel. We'll be watching Kyle. Catch you there. All right, guys. Peace. Peace.